Why is naming a guardian, if you have minor children, in an Illinois will a non-negotiable for parents? And the basic answer is it's the best way to tell the court who you want to care for your children. And you could even say how as well. But who is the most important thing? Otherwise, the court is going to look at all the evidence available and try to figure out what's in the best interest of the children. So if you have in your will, which is signed in front of a notary and two witnesses with a lot of legal formalities, and it is a legal document that's filed after you pass away, that's the best way to specify who you want to care for your children if you're not around. How do you leave money to your kids when you pass away without just giving them all of it at age 18? The most common way of doing that these days is through something called a trust. You could do it with a will that says, if I pass and they're under 18, do this, this, and that. But that's part of the probate process, which is public and can be a bit of a mess. So the simplest way to make sure an 18-year-old doesn't get a big pile of money is to specify that in what's called a trust. You can use a simple revocable living trust that's either holds title to your house or is the beneficiary of everything that says, look, when I pass away, gather up everything, pay all the bills, and put everything in this trust, or you could think of it like a suitcase, and then pay it out to the beneficiaries subject to certain guardrails or conditions. One of the conditions can be age. And so a lot of standard trusts in Illinois will say that nobody gets a distribution until they're at least 25. So if your child is between 18 and 25, it stays in that trust or that suitcase for their benefit, and your successor trustee or suitcase holder can manage it for their benefit and dole it out for typically, and this is subject to the details of the trust, but the most common things we say on trust is health, education, maintenance, and support, which can be really formal definitions if need to be, but give the trustee a lot of discretion to properly support them, but don't give them a big checkbook. So Junior can get a nice Honda Civic to go back and forth to community college, but isn't getting the Maserati. A testamentary trust in Illinois can help with your children's inheritance. A testamentary trust in Illinois is just a trust that is created based upon someone's passing. In some trusts in Illinois, when someone passes away, we can say, well, we have this basic trust that kind of does everything we want. But if one of our children has special needs, or they're a minor, or there's certain conditions we want met before they get the money, or certain conditions in which they don't get the money, then we can have a separate trust created upon your passing. What you'll want to do is either have that trust created ahead of time or be very specific in your existing trust of exactly what to create, how it works, and what conditions you want. Should the guardian and trustee for your children be the same or different people? When you're doing estate planning in Illinois and you have minor children, picking who the guardian is can be an agonizing decision, or picking the successor trustee can be a heart-wrenching decision as well. So when in doubt, if you get the right people in the right order, the same people in the same positions is fine. In a perfect world, if you would like to separate who is caring for them physically, day to day, and who's managing their money, then I recommend having a different person or a different order of guardians or people caring for the children versus your successor trustees or people managing the trust. What happens to your children's inheritance if you remarry after making your estate plan? And the short version is nothing. Your estate plan is still in place. Your marriage gives your spouse a certain small amount of rights to demand $20,000 if you pass away, or maybe homestead rights to the primary residence. But all the other parts of your estate plan still stay in place for your children. So not a lot changes when you get married. But if you're now a blended family and you have very different wishes, then you may want to each do your own estate plan or look at doing slightly separate estate plans. If you're getting remarried and you want all of your children of the blended family, both you and your spouse's children, treated equally, or you want to customize things, that is typically a good time to revisit and update your estate plan.